forward and back for me.
Hello and welcome back. Welcome to Chapter 13, Juvenile Justice, Probation, and Parole. So today our focus is going to be on juveniles. And the process with juveniles is substantially different. The big thing I want you to remember about dealing with juveniles is that in the criminal justice field, we consider juveniles rehabilitatable, meaning we want to give them every opportunity, every chance they have to mend their behavior before we take any kind of punitive action. That being said, another thing I want you to remember out of all this lecture is that we use different terminology for juveniles, but essentially some of those things mean the same. For example, adults are sentenced, juveniles receive a disposition. Adults are arrested, and juveniles receive an intake. So keep that in mind as I go through the lecture. Let's begin with talking a little bit about juvenile crime. Actually, if you believe it or not, juvenile crime's declined a little bit in the past several years. They do account for 17% of all the violent crime in America, so, looking at the scheme of things, that's a little bit high. About 26% of all property crime each year that occurs in the U.S. is committed by juveniles. So, as you can tell, their penchant is for property crime. The whole entire juvenile justice system is based on the concept of parens patriae, which means essentially the government comes in and takes control of your child. If a child is deemed, if it's deemed that parents can't take care of their kids, or for whatever reason, the government will come in and assume total responsibility, and then the parents can regain custody of their children. They have a lot of hoops they have to go through before that happens up. So let's talk a little bit about the jurisdiction of juvenile courts. When I say jurisdiction, I mean who has control over the situation. So in this case, we talk about age. So the jurisdiction of juvenile courts, it varies from state to state. And the age in which a person is still considered a juvenile ranges from anywhere from 10 to 17 years old at the time the act was in fact committed. So when we look at juvenile offenses, there are two different types we have to look at. First of all, we look at juvenile delinquent acts, and those are in fact punishable under the state's penal code. Now, in opposition to that, we have what we refer to as conduct in need of supervision, CINS, and that's acts that would be punishable if committed by adults, or would not be punishable rather, if committed by adults. Another category of juveniles that our court system handles in the juvenile court is juveniles as victims. So juveniles that have been neglected or abused fall under the jurisdiction of the juvenile court. Let me back up to CINS for a second. If you've heard the term status offense, status offender, that's where CINS comes in. A status offense is an offense that, if an adult committed it, wouldn't be punishable by a crime. For example, truancy or smoking or anything like that. Okay, so we've all heard of juveniles that have committed heinous crimes, right? Murder, things like that. So I've also heard a lot of times people in the public say, oh, well, you ought to try him as an adult or try her as an adult. Well, it's not that easy to get a juvenile from juvenile court over to adult court. But when that happens, we call that a waiver. And there are three different types of waivers that we look at. Number one is a judicial waiver. And that means the judge has the authority to waive that particular case from juvenile court over to adult court. The second type is what we call a prosecutorial waiver or concurrent jurisdiction. And that means the prosecutor has the discretion, the choice, to either try that case in juvenile court or adult court. The third type of waiver would be a statutory waiver or a statutory exclusion or something to that effect. And that means the state legislature has already enacted a law that determines who or what type of juvenile gets tried in adult court. And every state has some type of waiver. to try juveniles into adult court. So once transferred, the juvenile becomes an adult for the purposes of trial and sentence. In theory, the transfer decision rests on several different factors. Number one, the severity of the offense. Number two, the prior criminal record. Number three, the responses the juvenile had prior to juvenile supervision and treatment. And number four, future danger to the community. So all those things have to be taken into consideration before a case is waived to adult court. And let's go over a little bit of the process aside from the waiver. The first phase is called the intake phase. And that is where a juvenile's behavior has been brought to the attention of the system. So a probation officer or some other kind of personnel member, maybe an intake officer or maybe a police officer, they screen that juvenile to determine how the case should proceed. Sometimes a warning is sufficient. See, not every case that's brought in for intake has to go to court. You know, the intake officer has quite a bit of discretion when it comes on how to dispose of that case. So sometimes a warning is sufficient, like I said. Sometimes they'll do an outside referral to a social service agency or a drug court. That's another alternative. Third alternative would be diversion, and we previously talked about that in several other chapters. The next thing is they could determine whether or not the case should move toward adjudication in the juvenile system. Remember, I told you at the beginning of this lecture, adjudication is a fancy word used in the juvenile system, meaning trial. So if the case is if the case is serious enough, then a waiver may be used. So a delinquency petition can then be filed if the case is handled formally. If it is handled formally, then it would go into the actual court system. A couple things I want you to keep in mind. First of all, the intake may also include some type of crisis intervention or screening for detention. They have to decide whether or not that person, that juvenile, is an appropriate candidate for release. Another thing to consider is the police can hold that juvenile for up to 24 hours before they even have to do anything with the case. If they do decide to detain that juvenile, the juvenile has to be kept out of sight and sound of any adults, and that's pursuant to federal law. So let's talk a little bit about adjudication. So phase 1, intake. Phase 2, adjudication. Adjudication is equivalent to a trial in adult court. The proceedings are far less formal than adult court, and the judge is way more active, okay? The juveniles do not have the right to a jury trial or to bail. There are a couple quintessential cases that have what we consider landmark cases when it comes to juvenile rights. And the first one I'm going to talk about is Henri Gault in 1967. And that's the leading case talking about due process for juvenile justice. And the U.S. Supreme Court said that neither the 14th Amendment nor the Bill of Rights is for juvenile or for adults alone. So that being said, the Bill of Rights and the Constitution, 14th Amendment particularly, do in fact apply to juveniles. In the Henri Gault case, it was the first case decided by the U.S. Supreme Court that gave juveniles due process rights. So here's some of the rights that they received as a result of Henri Gault. They have to give 4 basic process rights. Number 1, reasonable charges or reasonable notice of the charges. They have to be able to have counsel appointed by the state if the juvenile is indigent, cannot afford counsel. They have to have the ability to confront and cross-examine witnesses. And they do have the privilege against self-incrimination. So that's the adjudication phase. The third phase, disposition. Disposition is the equivalent of sentencing in the adult court. There are a couple different types of sentences, but the one I want to hone in on for the sake of this lecture, time permitting, is the blended sentence. Those are sentences where state laws that allow juvenile judges to impose both a juvenile and an adult correctional sanction. In some states, the sentence starts in the juvenile system, but when the offender reaches adulthood, the case is transferred to the adult system. So essentially, let's say you get an 11-year-old kid comes in and they're tried as an adult. So they're sentenced as an adult. They receive 25 years. Remember at the beginning of the lecture, I said that you have to keep juveniles out of sight and sound of the adult, right? That being said, so what do you do with this kid from 11 to 18? Because they can't go to prison until they're 18. So from 11 to 18, they're in a juvenile facility. Then from 18 to whenever they're released, they go to an adult facility. Imagine, if you will, the impact that prison could have on an 18-year-old. I mean, nowadays, you know, kids are well matured, or they think they are, with ways of life. But when they go to prison, it's a totally different environment in prison. I know, I've worked there. And they look at those young people as just, you know, well, the predators look at the young people for, you know what predators look for young people for. So that being said, that's the blended sentence. Let's say they get probation. That's another form of sentencing. And juvenile probation is the most popular sentence for juveniles as well as adults. It works a lot similar. It works very similar to the adult. They have conditions they have to follow. They have procedures. And the probation can be formal or informal. Formal, they would, they would be under surveillance, the same as an adult. For example, the probation officer would go and do home visits, would do community visits, maybe at school, go talk to family, talk to friends, and so on. So over the last 2 decades, the number of formal probation cases has actually increased, and informal cases have actually decreased. That says a little bit about the state of our system. So when I said about the 11-year-old, you might find it odd that an 11-year-old would be sentenced as an adult, and it's not that odd. I do have some experience with working with juveniles, and I'll tell you, you haven't gained experience till you've been cussed out by an 11-year-old. And I worked at a facility that was a lockdown facility, but excuse me, these children, these youths, adolescents, they had criminal charges, but they also had psychiatric diagnosis, and that was the qualification that they had to have in order to be set or to serve their time at our particular facility, because it was considered a school. So they might be young as 10, but they had the mentality of a seasoned criminal. So you just never know with juveniles. Conditions of probation, like I told you before, that are similar to adult. There are standard conditions that apply to all juveniles, and then there are special conditions that apply to the special needs of those juveniles. For example, you might want to include a special condition of complete your GED, or to obtain employment, or to do various things like curfew and submit to drug urinalysis. There's also a concept called school-based probation, but I'm not going to really get into that for the sake of time. What I do want to talk about is intensive supervision probation, which is very similar to adult ISP. And that's where they have more frequent contact with the offender. The juvenile offender, will come to the office more and report, and probably have to submit to more random urinalysis and so on. So let's segue into aftercare. So if they're sentenced to a facility, remember when I talked a little bit about adults in prison, and I wanted to point out and specify that people on parole have been to prison, people on probation have not been to prison. So you keep that in mind. So aftercare is the juvenile term that we use for parole. Aftercare includes, or is considered, when juveniles are released from the state institutions, that they have aftercare. The release decision is left to the discretion of the institutional officials, except in 5 states that actually use juvenile parole boards. So that's a little different than the way it works in the adult parole system. And I also want to remind you that the federal system does not use parole. It was abolished in 1984. That's not in this chapter, but I want to kick that in so you remember it. And the federal system doesn't handle juveniles. They'll defer those to the state systems most often. Juvenile parole officers, they have similar duties as an adult. Let me give you a rundown on some of their duties. So they do predispositional and other investigations as directed by the court. They prepare written reports and recommendations to the court or the parole board. They supervise juveniles on parole or aftercare. They take juveniles in custody who violate their parole. So yes, they do have quasi law enforcement duties or authority where they can arrest juveniles. They also coordinate with the court, law enforcement, service providers, and family to make dispositional decisions. And it's important to get a well-rounded perspective when you're dealing with juveniles, because you might miss something, and then there's something out there about that kid that other people can bring up that you can work on and work toward rehabilitation. Revocation, that is a viable option if they don't follow the conditions of probation or parole. Revocation works very similar as in the adult world. The probation officer files a petition to the court. Remember, only the judge can have probation revoked. At that time, the judge will determine how they want to dispose of the case. Thank you. That wraps up Chapter 13. Contact me with any information you want me to elaborate on or anything else. Thank you very much.